Hi, my name is Kimberly Lau, and I chair the Title IX in College Disciplinary Practice of Warshaw Burstein, a mid-sized law firm in New York City. Our practice involves the representation of student rights and faculty rights at institutions of higher education and K-12 nationwide. Today, I'm with my colleagues James Figliozzi and Brandon Lin, who will also be presenting with me. Collectively, we have nearly 20 years of experience in handling educational matters across the country. Today, we will share with you an overview of Title IX of the Education Amendments of 1972. We will begin with a discussion of what Title IX is and what changes we can expect to see. Although the statute itself makes no mention of athletics, Title IX is historically known for increasing gender equality in high school and collegiate athletics. In fact, early lobbying efforts to enact Title IX were based on college athletics. But college athletics is not all Title IX applies to. Let's begin with the statute itself. No person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. So Title IX specifically prohibits gender discrimination in education institutions. As long as those education institutions receive federal funding, they must comply. That amounts to about 14,000 public school districts and more than 7,000 institutions of higher learning who must comply with Title IX. Now, an education activity or program encompasses every single aspect of education, including course offerings, counseling, financial assistance, student health services, housing, and athletics. The enforcement of Title IX is overseen by the Office for Civil Rights, otherwise known as OCR, which is a sub-agency of the U.S. Department of Education. Under the Obama administration in 2011, OCR issued a number of guidance documents to all colleges and universities across the country to increase awareness and vigilance in addressing the issue of campus sexual harassment and sexual assault. Sexual harassment and sexual assault were viewed as a form of sex discrimination, prohibited by Title IX. Over the last decade, Title IX has largely been focused on eradicating sexual misconduct on campuses. So today, we are focused on the formal rulemaking process that the Department of Education is engaging in to make proposed changes to how Title IX is enforced on educational campuses across the country. Here is what the rulemaking process entails and where the Department of Education currently is in that process. You'll see from the slide that public comment period just ended earlier this week on September 12th. Now, the department is going to review those comments that were received during that period, which is generally 60 days, and incorporate the comments into a final rule. Now, the Department of Education has been granted rulemaking authority by Congress to issue regulations effectuating Title IX. While Title IX has been in place for 50 years, it's notable that the department has only engaged in the formal rulemaking process 3 times. This year marks the 3rd time. This is also only the 2nd time the department has issued regulations addressing sexual misconduct specifically. The first time was in 2020 under the Trump administration. So how has the department enforced Title IX all these years? Through guidance documents. Periodically, the department has issued guidance documents which were not legally binding and did not have the force of law to direct schools on how to address sexual misconduct. As we discussed a moment ago, any school that receives federal funding must adhere to Title IX. If a school fails to do so, they risk the loss of millions of dollars of federal funding. So, Even though the department's guidance documents over the years were not legally binding, no school was going to risk violating the guidance documents and in turn losing such vital federal funding. Title IX is codified in the Code of Federal Regulations at 34 CFR Part 106. For comparison purposes, when the department went through the formal rulemaking process under the Trump administration, the Notice of Proposed Rulemaking was published on November 29, 2018, and during the public comment period, the department received over 125,000 comments. The hot topic for the proposed rulemaking then was the installation of due process rights for those accused of sexual misconduct. The department took over 1 year to review the comments and published a final rule in August of 2020. Now, under the Biden administration, the Notice of Proposed Rulemaking was officially published in the Federal Register on July 12, 2022. Notice and comment period was open for 60 days and, as I mentioned, had just closed on September 12th. Over 235,000 comments were submitted. That's over 100,000 more than the last administration received. Hot topics include gender identity and due process. It's unclear how long the department will take to review all the comments, although sources claim that it will not take as long as the last administration. For the first time, pregnancy and gender identity are now included as prohibited categories of discrimination under Title IX. While discrimination on the basis of pregnancy is not technically new, it's more spelled out for the very first time. However, the category of gender identity is new and is the subject of significant controversy, which I will touch on in a minute. Discrimination on the basis of either category could invoke the grievance process under Title IX, which my colleague will also go into detail later on in this presentation. Under the 2020 regulations, sexual harassment was defined as severe, pervasive, and objectively offensive. If a complaint of sexual harassment did not meet this definition, the 2020 regulations required its dismissal. Practically speaking, schools did not dismiss these complaints. Instead, they decided to take the complaints anyway, but prosecuted them under separate policies containing less rights than their Title IX counterpart policies. However, under the proposed changes, Title IX scope has been redefined. Under the proposed changes, Title IX prohibits both sex-based harassment and sex discrimination, with sex-based harassment referring to sexual harassment, sexual misconduct, sexual assault, and those types of complaints, whereas sex discrimination refers to discrimination on the basis of sex stereotypes, pregnancy, and gender identity. Notably, different procedures apply for sex-based harassment versus sex discrimination. Generally, only sex-based harassment complaints would trigger a grievance process that provides for written notice, an advisor, a possible hearing, and some level of cross-examination. For those accused of sex discrimination, such rights are very limited. You would only be granted some form of notice, some form of credibility evaluation, and an appeal. Currently, under the 2020 regulations, only complainants or Title IX coordinators may file a sexual harassment complaint on college campuses, and in K-12 settings, a complainant guardian or Title IX coordinator may file such a complaint. Also, the alleged victim had to be participating in or attempting to participate in an education program or activity at the time of the filing. This meant that if the incident at issue occurred several years ago and now the student is no longer enrolled or has graduated, the school did not have to accept the complaint. Under the proposed changes, for sex-based harassment complaints, there is no change in who can file the complaint. It may be filed by the alleged victim, the parent or guardian, or the Title IX coordinator. But for sex discrimination complaints, anyone who observes such issues can file a complaint. Also, under the proposed changes, any student who was participating in an educational activity or program at the time of the incident may file a complaint even if he or she is not a student at the time of filing. So again, that's one of the biggest changes. The timing of when the relevant time period is now, were you a student at the time of the incident, not were you a student at the time of the filing. So a student who graduated, for example, could file a complaint if the incident occurred while he or she was a student. Also, a student athlete who is visiting from another school for an athletic event could file a complaint at that school if they are the victim of sexual assault while visiting for the athletic event. Now, I've touched on this earlier, that gender identity is a new category that has been included in the proposed changes as being protected from discrimination under Title IX. Politically, this has been one of the most controversial provisions under the proposed changes because not everyone agrees that sex should be defined by gender preferences as opposed to the biological sex you are assigned at birth. Again, there were 235,000 comments submitted during the notice and comment period, and the issue of gender identity was raised quite a lot. In fact, it also received a lot of attention in the news. To support the addition of gender identity under Title IX, the department relies on the U.S. Supreme Court's decision in Bostock v. Clayton County, a Title VII case that explained how it's impossible to discriminate against a person for being homosexual or transgender without discriminating against that individual based on sex. The court stated, take an employer who fires a transgender person who was identified as a male at birth, but who now identifies as a female. If the employer retains an otherwise identical employee who was identified as female at birth, the employer intentionally penalizes a person identified as male at birth for traits or actions that it tolerates in an employee identified as female at birth. While the Bostock decision involved an analysis of Title VII, it should be noted that courts often look to Title VII case law when deciding Title IX cases, given that Title IX was modeled after Title VII. While this is the first time gender identity will be codified under Title IX, this is not the first time the department has attempted to protect gender identity under Title IX. Gender identity was previously covered by guidance documents issued by the Obama administration. But these guidance documents were revoked by the Trump administration and replaced with guidance stating that sex is based on one's biological sex assigned at birth. These documents were then revoked by the Biden administration. The department states in its preamble to the NPRM that it is not defining sex in Title IX through the inclusion of gender identity. In fact, the department states that it will allow the states to decide how they want to define sex. As an example, the department states that it will not dictate whether states must add non-binary as a sex characteristic, and will leave it up to the states to determine whether they will do so. That said, the addition of gender identity as a protected category under Title IX effectively does define sex, because Title IX will preempt any state law, for example, that does not protect non-binary students. And now I'm going to hand it over to my colleague.
Thank you, Kimberly. The Notice of Proposed Rulemaking creates a new proactive duty for Title IX coordinators to monitor their programs for potential barriers to filing discrimination complaints. These barriers can include just a general lack of awareness among the student body and employees about what their rights are and how to file complaints, but it can also include language barriers and disability. In order to monitor for barriers, the Department of Education has made a few suggestions for what schools can do. One suggestion that they've made is campus climate surveys. They can also get directed feedback from complainants who've already filed complaints to see what sort of barriers they may have experienced when coming forward. And they can also set up anonymous emails or websites where students can submit their the barriers that they might be facing and make the school aware of that. And then schools are required to remedy those barriers so that it's easier for students going forward to report sex discrimination. The NPRM also proposes removing the actual knowledge requirement. The actual knowledge requirement was instituted by the 2020 regulations, and essentially Gebser and Davis are two Supreme Court cases that said in order to hold a school liable for money damages, there needs to be actual knowledge, which means that constructive knowledge is not enough. The Department of Education has turned around and said, that might be what the rule is for private rights of action to recover money damages, but for enforcing Title IX in the agency realm, we're going to say that constructive notice is enough, and they're doing this by essentially turning everyone into a mandatory reporter. So what this means is, if you're a mandatory reporter and you find out that there might be some sort of sex discrimination going on, you have to go to the Title IX coordinator and report it. There are exceptions to who a mandatory reporter is. Schools can set up confidential employees. Confidential employees include clergymen, physicians, people who communications with them are already privileged. They don't have to go tell the Title IX coordinator. And schools can also make a list of resources and individuals and say, if our students go speak to these people, everything that they say will be held confidentially between them, and it's not going to be run up to the Title IX coordinator. And there's also an exception for IRB-approved researchers. These are people who are doing research into sex discrimination. If during the course of their research they learn of sex discrimination, they don't need to report it to the Title IX coordinator. In the K through 12 setting, if you don't fall into that category of confidential employees, you're going to be a mandatory reporter. This includes everyone at a K through 12 school. So if you're the janitor and a student in 8th grade comes up to you and tells you that they were inappropriately touched, you need to report that to the Title IX coordinator. In the post-secondary realm, a lot of people are still mandatory reporters, but it's a bit of a smaller group. Essentially, if you have the authority to institute corrective measures, or if you're an administrator, a professor, teacher, in some sort of position of authority at the school, you're going to be a mandatory reporter, and if you learn of sex discrimination, you'll need to report it to the Title IX coordinator. Everyone else, such as maintenance workers, grounds crew, the janitor, if you're at a university and you learn sex discrimination, you can report it to the Title IX coordinator, but at the very least, you're going to be required to inform that individual of who the Title IX coordinator is, provide their contact information, and provide information about how they can report the discrimination. The proposed rules will also change the definition of sex-based harassment. Now remember, there's two categories here. The sex discrimination is the broad bucket, and sex-based harassment is that smaller bucket, which is going to include sexual misconduct cases, predominantly. Under the 2020 regulations, the standard was severe, pervasive, and objectively offensive. If you met that standard, it was sexual harassment, and it had to be adjudicated under Title IX and go through the grievance process. Big criticism there was the word end. A lot of critics said, well, what if it's severe, but it's not pervasive? Does that mean schools don't have to investigate it? The DOE is addressing that now. They're going back to what it was before the 2020 regulations and actually elaborating, expanding upon that. And they're saying if the conduct is severe or pervasive, such that based on the totality of the circumstances and evaluated subjectively and objectively, it creates a hostile environment, If you meet that standard and it's a hostile environment, or you have quid pro quo harassment or sexual assault, dating violence, domestic violence, you're going to end up in the sex-based harassment bucket, and that's going to be covered by Section 106.46, and James is going to talk about those procedures a little bit later on. The factors that schools have to consider for whether or not it's a hostile environment are outlined on the slide here. You can see that the first prong really deals with the severity of the conduct. How severe is it impacting you and your access to education? If you're unable to go to school anymore and you're missing classes, that's going to weigh heavily in favor of being a hostile environment. Prong 2 asks how pervasive is the conduct. If it's happening every single day, that's more likely to be a hostile environment than if it's just a one-off incident. Prong 3 looks at who the parties are in the case. If there's power dynamics in play, if it's a professor harassing a student, that's more likely to be a hostile environment than student-on-student harassment. Prong 4 looks at the context of the conduct, where it happened, the control that the school has over where it happened, when it happened, and who the actors are. If it's happening at a fraternity party on campus, the school is going to probably have to take that into consideration. It's going to be more likely to be a hostile environment. But even if it's something extraordinarily severe that happens off campus by a non-student, then that might not be a hostile environment because the school doesn't have any control over the location or the individual. And then finally, schools are able to look at other sex-based harassment that might be going on campus and see if maybe considering that factor, it tips it over the edge to create a hostile environment in this case. And if you meet those prongs, you're going to end up in the gender-based, the sex-based harassment category. But even if you don't meet those prongs, you could still be facing a grievance process just under the sex discrimination category. An example of sex discrimination would be someone who is denied a research position simply because of their sex. That doesn't rise to the level of hostile environment, but you're still being discriminated on because of your sex, and that's still going to be covered by Title IX, and that would be adjudicated under 106.45. The complaint under the 2020 regulations needed to be a formal complaint signed and written by the complainant themselves, the Title IX coordinator, or in the case of K through 12 students, it could have been their parent or guardian. This has been relaxed, and now it doesn't need to be signed anymore. It can be any written or oral request to initiate a grievance procedure. In terms of sex-based harassment claims, it's pretty much the same individuals who can make complaints now as under the 2020 regulations. They tweaked the definition a little bit where it's parents, guardians, or any other legal representative for those K through 12 students, but essentially the same people are making those complaints. The big change here is for sex discrimination claims. So under sex discrimination claims, any third party participating in the school's program or activity when discrimination occurred can file a complaint, even if they are not in any way affected or even benefited from that discrimination. For example, if you have two students apply for a prestigious research position in a lab on campus, the female student much better qualified, but the male student gets the position. The first day in the lab, the professor that hired him says, that other candidate was great, but I didn't want a woman working in the lab. Clearly, that female student was discriminated against because of her sex. Even though that male student has benefited from that, he can file a complaint alleging sex discrimination for that refusal to hire her because of her sex. This can kind of lead to things getting out of hand. Sometimes some people who are victims or have been discriminated against don't want to file complaints themselves. This is taking away some agency for the person who is actually affected to decide for themselves what they want done. So this could be an issue in the future where maybe you have a runaway train situation where someone filed a complaint, the school starts investigating it, and before anyone can stop it, it's already underway. But I think the DOE sees that as not really an issue. They think that complaints are being underreported. So with this, plus the mandatory reporters, I think they're going to view it as a net positive that all these extra complaints are being filed because in their view, too many things are going unreported. For supportive measures, this is a fairly large change, even though the language isn't necessarily that different. The supportive measures still need to be non-disciplinary and non-punitive. And under the 2020 regulations, the burden could technically be placed on the respondent, but in practice, everyone's understanding was anything more than a mutual no-contact order was too much of a burden to be placing on the respondent because they're presumed innocent, and often schools will have a list of 20 sanctions, and if you impose one of those sanctions as a supportive measure, you're disciplining the student before any finding responsibility. The Department of Education is saying, well, we're clarifying the rule. You actually always could have been putting the burden on respondents. They're making it much more explicit now that you can do that. And just because something is on the list of possible sanctions does not mean that you can't impose it during the supportive measure, as a supportive measure during the pending grievance process. The respondent may challenge any burdensome supportive measure before it goes into effect. But this is going to be a big shift because essentially most, if not all, schools are going to start putting the burden on respondents in these cases, even though on the one hand they'll be punishing the student, but on the other hand they'll be saying, don't worry, you're presumed innocent. You just can't go to class anymore. So we'll see how that goes. But hopefully they are urged to consider the least burdensome supportive measure, so hopefully it doesn't get out of hand. Next is the jurisdiction. So under the 2020 regulations, the jurisdiction for Title IX was really narrowed quite a lot. Study abroad programs were no longer covered, and if misconduct occurred off campus, even if it involved 2 students, a lot of the time that was not going to fall under the Title IX regulations, and the school was forced to dismiss it unless it was at a fraternity house off campus maybe. This was criticized heavily, I think, by both sides. On the victims' advocate side, the complaint was you're letting all this misconduct go unchecked, and attorneys who were representing respondents felt hard done by because the school would dismiss the case under the Title IX regulations and then just bring it under a parallel process where the student had no rights to review the evidence, cross-examine witnesses. So really nobody was happy with how that was being handled. Under the proposed regulations, the Department of Education is going to reopen it to apply to American students who are in American study abroad programs. Just because you're out of the country doesn't mean Title IX is not going to apply to you anymore. They're also expanding it where if the school has jurisdiction over the students, just because it happened off campus doesn't mean Title IX is not going to apply. So you're going to have a lot more cases being adjudicated under the Title IX grievance procedures than you had in the past. Even if maybe there's not more complaints being filed, it's just they're going to be funneled through the Title IX process now. And finally, students who, in the past, if you had graduated, you weren't able to, you would struggle to get the school to take up your complaint, again, because you were no longer actively participating or trying to participate in the program. That's, as Kimberly stated, that's no longer the case. Even students who are just there for a day or two to participate in athletics can now file complaints, and the jurisdiction will expand to those individuals, even though they're not students. Even prospective students can file complaints, depending on the circumstances. And with that, I'm going to turn it over to James.
Thank you, Brandon. Now that you've heard about the origination of a Title IX complaint, I'm going to walk through how these complaints are resolved. One potential option for resolving Title IX complaints is the informal resolution process. True to its name, this informal resolution process lacks the convention of a hearing and is more akin to a non-binding mediation where a neutral party is used to facilitate an outcome agreeable to both the complainant and the respondent. Under the 2020 regulations, Schools can only offer the option of an informal resolution after a formal complaint has been filed. Notice of and consent to the informal resolution process must be in writing, and students cannot be forced to participate in the informal process. Additionally, the informal resolution process cannot be utilized when the allegations involve a university employee sexually harassing a student. Under the proposed regulations, schools can bar the use of the informal resolution process if they determine that the alleged conduct would present a future risk of harm to others. In such a case, schools can decline to offer the informal resolution process even if all parties wish to utilize it. As a result, both complainants and respondents will potentially have fewer options for resolving Title IX matters if the proposed regulations are adopted as written. This is unfortunate. In our practice, we've had success using the informal resolution process to resolve cases that involve conduct such as stalking, which may fall under the umbrella of conduct that schools determine to present a future risk of harm to others. As currently written, the proposed regulations could require students to go through a formal process even if it could have been resolved without the stress that accompanies that formal process. If a formal process is required, then the school needs to deal with the appropriate standard of proof. Under the 2020 regulations, the same standard of proof must be used for all Title IX disciplinary proceedings, regardless of whether they involve students or faculty. Schools are able to choose either the preponderance of the evidence standard or the clear and convincing evidence standard. Under the preponderance of the evidence standard, the burden of proof is met when the party with the burden convinces the fact finder that there is a greater than 50% chance that the claim is true. Under the more exacting clear and convincing evidence standard, the party with the burden must present evidence that leaves a firm belief or conviction that it is highly probable that the factual contentions of the claim are true. In Title IX matters, the burden of proof is always on the institution to prove that that a violation occurred. And that remains the case under the 2020 regulations and the proposed rules. However, under the proposed rules, the default standard of proof is preponderance of the evidence. Schools can only use the clear and convincing evidence standard if it is used for all comparable proceedings, such as other discrimination complaints. Additionally, under the proposed rules, schools are no longer required to use the same standard of proof for student cases as they are with faculty cases. Due to the more arcane nature of the clear and convincing evidence standard, it is very likely that schools will overwhelmingly and perhaps exclusively rely on the preponderance of the evidence standard when determining Title IX matters. And we're moving on to the allegation. Under the Notice of Proposed Rulemaking, schools are only required to provide written notice of the allegations to the parties after receiving a complaint of sex-based harassment. This notice can also be delayed due to safety concerns following an individualized safety and risk analysis, and those are new elements under the proposed rules. The notice that the schools provide must include a statement that the respondent is presumed not responsible. The respondent may have an advisor of his or her choice throughout the process. The respondent is entitled to access relevant evidence and or the investigative report, and, if applicable, provide an additional notice on the prohibition against false statements. This additional information is not required for sex discrimination matters, which don't even guarantee an advisor of the respondent's choice. Schools are also able to remove a respondent prior to adjudication if they perform an individualized risk assessment that concludes that the respondent poses an immediate threat to the health or safety of another student. The respondent can immediately challenge any adverse decision. And while certain sex-based harassment claims could conceivably rise to the level of requiring immediate removal of the respondent, it's difficult to imagine how a sex discrimination matter would constitute an immediate threat to the health and safety of another student. We're moving on to the investigation process. And on this slide, we can see how changing one word in a regulation can make a huge difference. And a very significant change the notice of proposed rulemaking allows schools to utilize one person as the investigator and decision maker in Title IX matters. The 2020 regulations explicitly forbid the use of this so-called single investigator model. The single investigator model was regularly utilized by schools prior to the issuance of the 2020 regulations. And while some may argue that the use of this model can be beneficial from a cost and time-saving perspective, federal courts have recognized the inherent danger of such an arrangement. In Doe v. Brandeis, a 2016 case from the District of Massachusetts, the court noted, quote, "The dangers of combining in a single individual the power to investigate, prosecute, and convict with little effective power of review are obvious. No matter how well-intentioned, such a person may have preconceptions and biases, may make mistakes, and may reach premature conclusions," close quote. In our practice, we have come across situations where investigators include irrelevant or prejudicial information in their reports that, if left unchecked, has the potential to sway the outcome of the Title IX matter. While the presumption of innocence remains intact, the Department of Education's decision to allow schools to revert to the single investigator model represents a major step back with regard to due process, both for respondents and complainants. It also jeopardizes the perceived legitimacy of all Title IX proceedings that utilize the single investigator model. Continuing with a little bit more about the investigation, under the 2020 regulations, schools are required to give the parties at least 10 days to review and respond to the evidence prior to the issuance of the investigative report. Schools are also required to provide the parties with at least 10 days to review and respond to the investigative report prior to the hearing. The proposed rules eliminate this clearly defined process and even eliminate the requirement that a live hearing be conducted at all. As currently drafted, the notice of proposed rulemaking only requires schools to provide the parties with a reasonable opportunity to review and respond to evidence prior to a decision being made. If a live hearing is held, the opportunity to review the evidence must occur before the live hearing. Presumably, the opportunity to review the evidence before the hearing must also be reasonable, but the statute as written does not explicitly state that. It's not unusual for there to be hundreds of pages of evidence in the form of text messages, emails, witness statements, and photographs related to a Title IX investigation. In one of our currently pending matters, there is an investigative report that is 20 pages long, which is manageable, but it also includes 320 pages of exhibits. In another matter that we handled, there were close to 700 photographs involved, multiple videos, multiple audio recordings, along with witness statements from almost 10 non-party witnesses and communications that the parties had with each other and with those witnesses. And in these situations, a school's interpretation of what is a, quote, reasonable opportunity to review and respond to the evidence could vary greatly from that of the parties, especially if they are students carrying a full course load. Without a clear time frame, parties and universities are sure to routinely disagree on what is reasonable when it comes to the opportunity to review and respond to evidence. And if the school does decide to offer a live hearing, schools can limit the party's opportunity to even respond to the evidence, to the actual hearing itself. In other words, the live hearing could be the only chance that the parties have to provide a response to the evidence. This is likely to create an unfair element of surprise for all parties and undermine the ability to effectively prepare for cross-examination, present rebuttal witnesses, and controvert evidence presented by the university or the opposing party. As Kimberly noted previously, one of the hot-button issues in these new regulations is the due process concerns that some people believe that they raise. And an important element of due process is the ability to cross-examine an adverse party and a witness. Under the notice of proposed rulemaking, schools are no longer required to conduct live hearings where cross-examination would generally occur. This is problematic from a due process standpoint and is arguably contrary to the constitutional protections that public universities are required to offer. In fact, the Department of Education has explicitly noted that public institutions in Kentucky, Michigan, Ohio, and Tennessee are bound by the Sixth Circuit Court of Appeals ruling in Doe v. Baum. In that case, the court noted, quote, if a university is faced with competing narratives about potential misconduct, the administration must facilitate some form of cross-examination in order to satisfy due process, close quote. Without a live hearing, it's unclear how public schools in the Sixth Circuit will meet their constitutional burden of providing parties to a contested Title IX matter with adequate due process. And while schools are not required to provide a live hearing, if they do conduct one under the new rules, the new regulations remove the explicit requirement that cross-examination be conducted directly, orally, and in real time. Coupled with the new requirement that the decision maker must screen all questions for relevance and permissibility before they're asked, it appears that the Department of Education is trying to create a scenario where all cross-examination questions must be prepared by the student and submitted to the decision maker in advance of any live hearing. This would greatly limit the effectiveness of cross-examination and potentially taint the decision maker's view of the case before the parties have had an opportunity to be heard. Additionally, taking regular breaks to allow the parties to submit new questions would also hamper the usefulness of cross-examination and needlessly subject all parties to a more protracted hearing process than necessary. Now, continuing with the analysis of cross-examination, under the 2020 regulations, schools were not permitted to rely on any statements made by a party or witness if they refused to submit to cross-examination. This provision has been struck down as unlawful and is currently not being enforced. In finding the provision arbitrary and capricious under the APA, which is the Administrative Procedure Act, the District of Massachusetts in Victims' Rights Law Center versus Cardona imagined a scenario where an attorney would advise their client not to attend a hearing so that inculpatory statements that they made, either within or without the process, could not be considered. And that case is currently on appeal to the First Circuit, but the appeal has been held in abeyance due to the issuance of the Notice of Proposed Rulemaking. Under the new proposed regulations, a party's own supportive statements cannot be considered if they refuse to submit to questions regarding their credibility. This is likely to pressure parties to submit to such questions either directly from the decision maker or on cross-examination so that their own supporting statements can be utilized in determining the outcome of the proceeding. However, this new standard does not apply to witnesses. And this is troubling, as allowing the decision maker to rely on witness statements that have not been probed for credibility, even if these statements cannot serve as the determinative factor in inferring responsibility, undermines the rights of the parties to confront witnesses and can lead to unreliable information impacting the outcome of Title IX matters. And once a decision is made, both parties have the right to appeal, and the appeal rules are not changing between the 2020 regulations and the proposed rules. Schools must offer at least 3 grounds for an appeal: procedural irregularity, newly discovered evidence, and conflict of interest. Schools may choose to offer additional grounds for appeal, and in our practice, the most common additional ground for appeal is that the sanction issued was excessive. And I'm going to hand it back over to Kimberly for some final thoughts.
Thank you, James. So, as you can see, we've covered quite a lot of material in our presentation, so I'm just going to hit some of the major takeaways that we'd like the audience to take away from this presentation. The first being that sexual harassment has been redefined with a broader application. As you can see under the proposed regulations, Title IX prohibits both sex-based harassment and sex discrimination, with sex-based harassment referring to sexual misconduct and those types of complaints, and sex discrimination referring to discrimination on the basis of sex stereotypes, sex characteristics, pregnancy, and gender identity. Another takeaway is that anyone who is not a confidential source is pretty much considered a mandatory reporter and must notify the Title IX coordinator or provide the Title IX coordinator's contact information on how to report sex discrimination if they learn of such incidents occurring. And the third takeaway is that pregnancy and gender identity have been added as protected categories under Title IX. Again, pregnancy is now spelled out more, even though it's not technically a new category, while gender identity is, in fact, a new category that will be codified under Title IX for the first time. Fourth takeaway is for sex-based harassment complaints, schools are no longer required to provide live hearings with advisor-led cross-examination in real time. Schools may use a single investigator model and conduct some level of cross-examination that does not need to be done in real time. Schools have the discretion to decide how much time they will allow the parties to review the evidence and or respond to the evidence. And schools also have discretion to decide when to give students time to respond to evidence if there's a live hearing. It could be before or during the hearing, or they could decide to allow the student to respond before and during the hearing. So there's a lot of discretion here on how schools can handle Title IX complaints. In conclusion, many of these changes to the grievance process represent, again, the new category of gender identity being a very controversial topic in and of itself, and as covered under Title IX, as well as an erosion of due process rights for those accused of sex-based harassment. With that and those takeaways, we will now open the rest of our time to any questions that anyone in the audience may have for us. Thank you.